It's so pushy.
I know. Oh, but it's not for that. Oh, yeah. I'm gonna look at it. Good afternoon, everyone. Welcome to Children and Families Committee. And before we start our business, I'm going to ask Senator Burns, mic number 12, to open us in prayer.
If you'll join me today in prayer, Father, we're grateful. We're grateful for life. We're grateful for the work that I need to do business for the people of Georgia. Your work that they do.
Well, what I wanted to tell you all is that I forgot to recognize our great staff. That's how. I'm not sure what next week's gonna look like, so I want to take the opportunity to thank Scott, David, Research and Press, and Holly, our legislative council. Thank you all so much for helping our committee run smoothly. And I think we also have at least one person on for one of the bills, but we have two bills this afternoon. And the first one is House Bill 291, which you should be very familiar with. The second one is House Bill 144 for hearing only today. And we do have sign-up sheets, which hopefully anybody who wants to testify can take advantage of. But I will say that we gaveled in this afternoon, and we have a few committee meetings this afternoon, but a lot of people have a long way to drive. So we're not in session tomorrow. We'll be working from home. And so I'm hopeful that we can keep our testimony brief, just so that everybody can beat the traffic out of here. So with that, Representative Scoggins, you want to tell us what you changed on 291? Because we heard this bill last week, and I know that you've worked hard on making changes that the committee asked for, and I really appreciate your hard work.
Yeah, I appreciate your time. You remember this bill just what it's doing. We're trying to expand our list of providers who can lay board and a guardianship proceeding. So we only set 3 4, and this increases by 4. And what we're adding, if you're looking on line 23, we're adding a physician assistant license under chapter 34, title 43, a nurse practitioner or a clinical nurse specialist that is trained in physical and mental health or has a mental health and psychiatric license unit. There's also title under chapter 26, title 23, and also a marriage and family therapist or professional counselor license under chapter 10. And we have experts with us today in each one of those categories that justify and continue to tell you what their expertise is. And if you need them, we'll be glad to testify. It's
Thank you very much. We'll see what questions the committee has, if any, and then we'll see. Senator Jackson.
I have a question about where the commas are. I'm not sure. So the nurse practitioner on line 24 that you read, a nurse practitioner or a clinical nurse specialist. So does the nurse practitioner has to have a psychiatric and mental health license? Is the question, or is that only specific to the clinical nurse?
come on.
I think it needs a comment.
I think so.
Good afternoon, I'm Robin Richardson, nurse practitioner, 25 years, nurse practitioner, specializing in geriatrics and dementia in Georgia. The answer to the question is no, the nurse practitioner does not have to have additional psychiatric or mental health education outside of what's provided in our national curriculum. Thank you.
So we're in the minute.
Okay.
So the rest of them.
I think it's too technical. I'm Gardner
argue that you don't need a comma, because both, it seems to me the legislative council can address this, maybe. This is intended to be a nurse practitioner or clinical nurse specialist who specializes in that area. Both are under chapter 26 of Title 43. If you add in a comma there between practitioner or, you'll have to somehow connect a nurse practitioner to Title 43. So I think that was intentionally written. If you look the next, a marriage and family therapist, professional counsel, license under chapter 10. It was intentional to leave that comment. So I just wanted to point that out. That it might actually change. We would have to add a whole bunch of words to make it consistent.
We can certainly let council decide
Just-
what we need to do there, but we have one more question. She can be thinking about that while we're answering Senator Barnes' question. This is reminding me of a lot of judiciary questions from the committee now. When we're talking about commas.
Yeah, I can say, Madam Chair, we're down to argue where the commas go. That's a good thing. I just want to thank the author and those that worked on this. I think it's much stronger and tighter and appropriate. We certainly want to be able to move these decisions as quickly and as appropriate as possible. So I just want to thank you for your work.
Excellent.
What do you recommend?
Or as a drafter, I think that the person who drafted this bill also did that for consistency because it wasn't done of the physician assistant, or excuse me, the nurse practitioner or clinical nurse specialist. And for consistency and the way that the code is written, a marriage, family therapist or professional counselor, I tend to agree with Senator Estes. It was probably it sounds terrible. Extra actual contents of the bills and this consistent. And I
Yes, yes, ma'am.
Any other questions? Yeah. Senator Estes, are you Mike?
Yes,
Did you have another?
I was gonna ask to make a motion at the appropriate time, but I think Senator Jackson might have a question. I'll ask it. Social worker, licensed social worker does not have a title attached. I know that was in the original bill or original law. Do we know whether there should be some kind of chapter and title attached to that?
Excuse me, Senator, what line are you talking?
27.
The licensed clinical social worker.
Yeah, so all the
Already in the code.
Yeah.
It's already in the code.
Yeah.
So we're not adding that. It's already there.
okay.
We do have some people signed up to testify, so let's go ahead and give them an opportunity. First, Aubrey Lyons.
Chair, members of the committee, Aubrey Lyons, the Licensed Professional Counselors Association and the Advanced Practice Nurses. I'll waive unless there's questions. I'll be happy to answer any questions. And I wrote the original bill years and years ago. So
Just for the record, for me, you support the bill.
we support the sub.
Thank you. That's what I needed to hear.
Thank you.
Thank you.
Thank you. Okay, Angie Smith.
Thank you, Madam Chairwoman. I am the current chair of the Licensed Professional Counselor, Social Worker, and Marriage and Family Therapist Composite Board. So I'm here to answer any questions that you may have from a licensing standpoint or a training education standpoint.
I'm not seeing any lights. So, oh, wait. Senator Jackson wants to ask you a question.
Yes, just from a, thank you, Madam Chair, from a training standpoint, are these folks that you represent, do you feel like they are trained in recognizing these types of competencies just by nature of their schooling and training already? Is that inclusive?
Yes, ma'am. I do
Will you
believe
pull the
that.
microphone down?
Yes, ma'am. I do believe that the clinicians that are licensed by our board are competent to perform these evaluations. We are already doing modified versions of this when we assess for lethality, we assess for risk. So I believe that our clinicians are trained and prepared to perform these evaluations.
Great, thank you.
Okay, thank you. Robin, you already spoke. Did you have anything else to add?
No, ma'am.
Okay. Elizabeth Apley?
Yes, Madam Chair, I represent the Georgia Association for Marriage and Family. We support the bill. We thank the author and appreciated working with us on the sub. I have Dr. Steve Livingston, a former board chair for the composite board available, and Dr. Dan Upshaw from Grady available to answer any questions that the committee would like.
Thank you. Dr. Livingston, can you hear us?
Yep, I can hear you. Thank you for having me on virtual. I'm receiving an infusion as we speak. So,
Okay, can you hear us?
yes, yep, yes, yep.
Did you have anything you want to add? I think you've been on there the whole time, so you've heard the conversation.
Yeah, I agree with all the testimony. I'm the legislative chair of the Georgia Association for Marriage and Family Therapy, and we support 291, this revision of it, and do believe that licensed marriage and family therapists, professional counselors, as well as social workers are all qualified to do this. I was chair of the board for 4 years and a program director for Mercer University's marriage and family therapy program in the School of Medicine. And I know that the training that marriage and family therapists receive is, would qualify them to do these kinds of evaluations. All three of us, professional counselors, social workers, and MFTs are credentialed to diagnose and treat mental illness. We all treat individuals, couples, and families. Sometimes marriage and family therapists get the label of just being marriage counselors, but we've been for 25 plus years in Georgia, treating individuals, couples, and families, dealing with a variety of issues and doing, similar kinds of things. And all three disciplines on this board all are qualified to do this kind of evaluation.
Thank you. Any questions from the committee? Okay, that's everyone we had signed up to testify. If there are no further questions, I'll entertain a motion.
I move that we do pass.
Okay, second by Senator Jackson. Further discussion? Okay, all in favor, raise your hand. Any opposed? Okay, thank you. Your bill passes. Who's carrying this for you?
Thank you, Senator Sam Watson.
Okay,
Thank you.
thank you. Okay, next we have House Bill 144. This is a hearing only. We're not voting on this bill today. Representative Lewis Ward, are you ready? Welcome to the Senate.
Thank you. Thank you, Madam Chair. What's that?
The Senate, Scottsdale.
I heard that.
Is this the first time you've been before our committee? Is this?
It
This
is.
isn't your first bill, is it?
It is.
Aha, okay, thanks for sharing that with us. Okay, go right ahead. The floor is
Good
yours.
afternoon, Madam Chair and members of the committee. I bring to you House Bill 144, LC number 480937S. This is a constituency bill. About a year and a half ago, a constituent came to me. Her brother was sick and his wife had stopped the family from allowing him to communicate with the family. He eventually passed away on December 24th of last year. And that's where we get the name, the George Burgess Act from. It's named in honor of her brother. When we took a look at the current code, the code does exist for a ward to communicate freely with anyone other than the guardian. But what this bill does, it just adds a little bit more oomph into the current code and We did have some conversations with DHS. They thought that there may be some conflict with the bill, with the current code, and also with the probate representatives for the probate judges. We had a meeting with them. And they provided us with code that they would prefer to see in the bill. And that's where we get the substitute, because we put in their code in the bill. We work with legislative counsel, and we also believe that there's no conflicts with the current code. So Section 1, what it basically does, it just indicates some ways that the ward can communicate with the guardian, with someone other than the guardian. And then Section 2 is Part D, line 17 to 25 is the code that the probate representatives ask us to include. And really, that's the bill.
Okay. Questions from the committee? Okay, we have one person signed up to testify, Judge Keith Wood. Come on up. You can just scoot over and let him get to the mic if you would.
Good afternoon. Members of the committee, I want to first thank you for the opportunity to be here to discuss this bill. And I want to start out by saying that.
Can you tell us where you're from?
Sure, absolutely. I am from lovely Cherokee County, Georgia. I'm the probate court judge. I am, again, appreciative of Representative Lewis Ward for putting forth legislation and having a concern for the adult ward. Certainly, that's a concern that as a probate judge, we have as well. And, you know, when looking at a bill like this, it's not that we have an issue, you know, with the idea that we want to have the tools to deal with situations such as this. It's just that we already have those tools. The language, even the substitute language, doesn't really add anything to something that we already have the ability to do. When you look at the statute as it is currently structured, you know, you have 29-420, which sets out these rights that a ward has, including the right to communicate with people freely. Then you have the code section 29-420, which says that the court, in situations where a ward is denied some right, the court has the ability to investigate the circumstances of that ward and determine if something needs to happen. And then when you look at code section 29-452, it kind of sets out things that the court can do if we find cause. Those include revoking or suspending guardians' letters, requiring additional security if they're required to be bonded, reduce or deny compensation, impose any other sanctions that we deem appropriate, issue, and this is the one I always like, issue any other order as in the court's judgment is appropriate under the circumstances of the case. So we have a really fairly broad ability to deal with situations such as this. You know, quite honestly, as a probate judge, if I have circumstances, and I've had these circumstances before when we believe that a ward has been prohibited from communicating with others, quite honestly, I'm going to go to removing a guardian before I do anything else. I'm not looking to find them. I'm not looking to, you know, slap them on the wrist. I'm looking to remove them because that's a serious problem. If, or in the alternative, the court has the authority to set out things like visitation plans and things of that nature that can more directly address that problem. It is not that I have an issue with what this legislation attempts to do. It's just I think it's something that we really already have the authority to do. And I don't want to muddy the water of something that we already have the authority to do, that we can do, and that we actually already do. And it's, you know, maybe this is a situation where it's a case where maybe someone didn't realize that authority was there, but it's there.
Thank you, Judge. Any questions for Judge Wood? Senator Jackson?
Thank you, Madam Chairman. Chairwoman, so to be clear, you're saying that people who are wards are already supposed to be able to have visitations, telephone calls, emails, and personal mail come to them, that's already existing in code? Is that what you're telling me?
I guess it really depends on how you want to define the term communication. I define it fairly broadly. I mean, if someone tells me, you know, I'm not allowed to have phone contact with the ward, I consider that, you know, that violating the spirit of what that statute provides. I mean, you can sit there and divine out what we mean by communication, and that's fine. I don't know that it adds or takes away anything. But yes, I think that the court can already act. The court already has the authority to act in those circumstances.
So in your expert opinion, if someone were a ward and they wanted to have regular visitation from someone, if that were denied to them, you're saying that they would have cause to come to court already if they were not allowed visitation with someone else?
Yes, absolutely. I think and I think what the court is trying to do in those circumstances, and again, every case is going to be different, but I mean, you're weighing, you know, you may have a situation where you have a ward that wants to have visitation with someone who may have been a predator before. Obviously, the court is not going to want such a circumstance, but that's what the court's there for, is to evaluate those circumstances and determine what is appropriate. But if it's a circumstance where the ward wants to have visitation with a relative and that's being denied, that's something the court should be addressing and has to address.
Thank you.
Senator Robertson?
Thank you. Thank you, Judge. Judge, would you say that when you deal with communications on the vast majority of these, when you get down into the weeds on a particular case, wouldn't you say that there's more times that you're specific in limiting communication based on some of the things you just said as far as a predator? And in predator, we don't necessarily mean sexual. We talk about financial predators and others that attempt to take advantage of these individuals. But on most of them, when you say communication, if it even has to be addressed, it's an extremely broad spectrum. And a lot of times, and I understand the representative's concern, a lot of times that communication is open and encouraged by the guardian of the individual. And so if we break it down to say email and all this other kind of stuff, what we're really doing is we're taking the cake and just slicing it into pieces, that they can already do all that. But that where your more detailed orders come from is when you're having to put prohibitions in there targeting particular individuals whose contact would not be conducive with the overall health of the individual we're trying to protect. Is that true?
That's true, but I guess, you know, I guess the way I look at it, this bill is attempting to address conduct by a guardian as opposed to third parties. So, you know, what the focus is if the guardian is prohibiting these communications, not if other people are having these communications. What the court is trying to address most of the time is a guardian who is prohibiting communications. If there is a circumstance where there's a third party trying to have communications with a ward that's not appropriate, you know, our expectation is the guardian is there to protect the ward. But in this, I guess in a similar vein, if the ward is allowing that communication, we need to address that as well. There's no question about that. But I think this bill is more focused on what is the guardian doing to prohibit these communications as opposed to what other people are doing.
Final question, Madam Chair, but is there anything in this bill that the court could not do today?
From my point of view, no. I think there was language in there about fining someone. And I guess my feeling about that is if I think that a case is extreme enough that I'm fining people, I need to be removing people. Because to me, that's a fairly significant step.
I'm not sure you're looking at the most recent version of the bill, because I think that was, what line is that?
Right, and I think it's more discretionary now than it was before.
Yeah.
Okay.
Not limited to.
Right.
Monetary.
Other questions for Judge Wood?
Thank you, Madam Chair. So just to, is there anything in this bill, if we were to pass it, that you think would undermine or be harmful? So I know we've addressed the other side of, do you think that we need it? But is there anything about passing this bill that would actually be hurtful or harmful?
No, I don't think to the extent that it does not limit anything that I can do, I don't have a problem with it in terms of, is it going to affect my ability to protect a ward's interest? No, I think that it's a very well-intentioned idea. I think that we already just have that authority, and you're just adding language to something that's already there.
Thank you.
Thank you, Senator Barnes.
Thank you, Madam Chair. This may be a question for the author, but I'll start with the judge. On line 10, the word communicate freely and privately, again, is already in code. Is that correct? Line 10, section 1, communicate freely and privately is already in code. Is that correct?
Correct.
And
That's
so-
already in the code.
And so the remainder of the sentence, that the additional language is an attempt, I think, it's an attempt to define what communication means. And I can communicate through these types of mechanisms: visitation, phone calls, emails, personal messages. Is that true? So we're trying to define what free communication is? Is that author?
Let's let the representative answer
Yeah.
that.
So line 11 just gives examples of ways to communicate.
But interestingly
It's not
enough,
limited to
it seems to imply that this is an exhaustive list. So we're not talking about social media or any kind of Facebook, Instagram technology change, because it's not email, but I can use messaging or messaging services. My concern is, if we codify those things over time, they will become obsolete, even if you listed them all out today. So if I can sit here and say, oh, I want to add Facebook Messenger, for example, to that, it's not email. Or I'm just saying, my concern is, not opposed to it, but if you specify this, and I don't see anywhere it says that these are examples, use the term through. I'm just concerned that we would become obsolete in a matter of years or less.
Thank you for that comment. I would be willing to include that word examples, or for instance, if legislative council would be agreeable to that, or is there some way that we can change that?
We have another question. I'm going to recognize Senator Estevez.
I'm wondering if including the word including through so that's one word that we would add to that sentence, because I can understand why you want to provide examples, because communicating freely and privately would most naturally come across as communication, whether it's written, verbal. Visitation is a word that sticks out there because that doesn't come naturally, like the word would be entitled to communicate through visitation. So I do appreciate the fact that is there, because I don't think that that's a natural example that people would think about. Whereas communicate freely and privately through telephone, email, and personal mail makes sense. So I appreciate the fact that visitation is in there. Maybe by including the word including, it makes it clear that we're talking about examples.
Ms. Carter, did you have a comment?
Yes, the easy fix at this point would be including but not limited to. That would be a legislative proper way to go with that issue.
Senator Payne, any question?
Yes, thank you, Madam Chairman. This is, even add that language, including but not limited to. I mean, that doesn't change the fact that it states communicate freely and privately with persons other than the guardian. I mean, we're not really changing anything with this language, because my good friend down there pointed out that, if you start listing the ways that they can communicate, you're putting you're putting that communication that's supposed to be freely and privately in a box. And when you start putting that communication in a box of what that communication, how it can come and when it can come, then it's going to quickly not be freely and privately anymore. That's my concern.
Okay, I didn't hear a question there, but I think there's a fair amount of questions about the exact wording that's in the bill and the impact that it would have on what the probate judges do, which is why we're having a hearing only. But as you know, this is year one of a 2-year process. And so I'm hopeful that you'll be able to work with the probate judges and get this language very tight and bring it back to us.
Great. Thank you.
Thank you very much. And we're adjourned.
It's very nice to meet you.